Let's talk about the Matterhorn project, or Matterhorn pipeline. I'm going to try to tell you guys, I'm going to download as much information as I can to you all, okay? A little bit I've spoke to some of y'all. I mean, you all are familiar with pipelines, you all know a lot, okay? But let's just try to, this is kind of more of an informal, let's exchange as much information as possible. So hopefully that's going to help you all. It's a stressful time, it's an emotional time. My family has gone through having a pipeline run through some property as well, not too long ago, or really 2 years ago, the Kinder Morgan crossover line, the 36-inch line. So this is a 42-inch line. So yeah, it's a big deal, and no one likes it, right? I was talking with one of you guys this morning, and the first comment was, does everybody know that there's nothing they can do about it? Well, to a certain degree, that's unfortunately true, right? And I'm going to get right from the very, let's cut to the chase. How can you keep the pipeline off your property? You really can't just say, sorry, go next door, and then they'll do it. But I like to try to keep them on tap, challenge them on every point if possible, from trying to take a different route off my property to a better route on my property to limiting what they do on your property, all right? So those are all key things, and we're going to jump into that, talk about that. So, it's been known by a lot of different, Whitewater, all us lawyers that do condemnation work, and I guess, kind of introduce myself. Philip Hundo, I've been a lawyer now, I don't know, almost 20 years. I did something before being a lawyer, so I think that helps me be a normal, regular person, I've worked at a big law firm, San Antonio and Houston, Fulbright and Jaworski, very good training. Then I got an opportunity to move back home. I'm from Wharton County, and so moved back home, joined a small firm, and now the small firm's kind of turned into a mid-sized firm. We've got about 8 to 10 lawyers. We do really everything, almost everything. Early on, lawyers have said, try to specialize. And so, I went from specializing in commercial litigation and all this kind of stuff to small town practice, doing a whole lot of everything, to now I finally, taken their advice and over the last 10 years, focused on land litigation, right? So what's my specialty? Land litigation. What does that mean? Yes, condemnation cases. About 90% of what I do is representing landowners and condemnation stuff. And when we talk about condemnation, what are we talking about? Hey, from roads to highways, power lines, you name it. It all kind of fluctuates. It seems like when, in 2020, when all of a sudden in March, the whole world stopped with COVID, all the pipeline projects stopped. Red Oak had this huge, so you guys have been dealing with right-of-way agents from Northleaf. Northleaf was handling this big Red Oak project from Oklahoma down to Houston, and all of a sudden, it's off completely. There's a pipeline project into E4. There's into E3 that kind of goes through Austin County, but into E4, canceled. So all this stuff got canceled. But what we also heard about COVID was the infrastructure bill, right? And that was all highway. So there's TxDOT is blowing and going with a lot of highway expansion. Well, actually in Fayette County, there's somebody from Fayette County here, Fort Bend County. So those, lots of different areas of condemnation, and we'll talk about all those. What everybody's, wanting to know here is, Matterhorn, right? And so we'll talk about Matterhorn, really the main line, and then there's some laterals. The lateral that juts off to go to Katy, and then there's a lateral that goes called East Bernard lateral that goes to Hungerford, okay, Texas. We'll talk about, on pipelines, what's the easement width? I think folks have already been asking kind of what's the plant easement width. I believe what I'm being told, 75 feet, okay? Is that hard, fast rule all the time? Yeah, pretty much. It could potentially be reduced from time to time. Now, the temporary workspace and additional temporary workspace, so you'll see words like TWS, ATWS, that's just temporary workspace, additional temporary workspace. That's when, if and when they need to make turns or borings, they'll have bigger areas than just the 75-foot. Things that are important to me is knowing about, valve sites, things like that. So typically these are things that, who in here, sometimes there's landowners that are contractors for pipeline companies or subcontractors. Anybody in here do pipeline work, construction work? It's what I'm normally told is every 5 to 7 miles they need a valve site. So knowing where that valve site is going to go is extremely important, right? And then also nowadays, the access points on pipeline projects, it's not that difficult. Why? Because there's so many roads and it's crossings and things like that. But depending on where you're at, the tracks, and how remote it is, you may have an access road through your property for them to do a lot of work up and down the pipeline. So, how are you going to be affected by, like I said, an access easement? Any questions or doubts or things that you all think about it, hopefully we'll at least touch on and you'll know, hey, I know Phil talked about that. The right to condemn, they have the right to condemn. You may want to say, well, how is that? Or, that they shouldn't, and all this kind of stuff. Correct, and I was explaining kind of to my kids, what I do, and, eminent domain, and, that's the power to take someone's property, right? The state constitution allows them to do that. The U.S. Constitution allows for the government to take property if it believes it needs it for the public good, public use. But, you can say, well, but this isn't the government. That's right. It's not the government. It's a private company. And so over the years, the laws have extended to say, hey, what they're doing is good, right? And I'm always kind of, in quotations, good. And the laws expanded, the public, what's the public use or what's the public good, right? And at times it gets a little too broad. There's cases where, hey, we think this vacant land here would be, good for a mall, and that's good for public use. And the courts have said, well, that's probably a little too far. But gas and I've posted some of the filings, and you'll see some of them with the Railroad Commission. In Texas and most states, it's pretty easy for a gas utility company or a common carrier to say this is for public good. In Texas, it's check the box with the Railroad Commission, and you kind of complied with, do you have a right, empowered eminent domain. So, but lots of other quasi-governmental agencies too, like LCRA we deal with. Lots of pipeline projects in the last 5 years. I said there was a gap of about 2 years where a lot were on hold. And right now, just Google on the internet, you'll see a lot of news about a lot of these other pipeline companies wanting to expand their capacity on certain lines too. Just like in even Whitewater, they've got a Whistler line that they're wanting to expand. So, most of these pipelines, I have this map on here to kind of show the normal routes. And most of the normal big routes of these big trunk lines go from, West Texas out here. There's a place called the Waha Hub. And it goes north of Austin, north of Round Rock. And then, Williamson County, and it takes this path down through Lee, Washington, Austin County down. Now, this was one, I kind of point this out. This green line, that's the Permian Highway Pipeline, Kinder Morgan. That was one that was in the news a lot about 2.5 years ago, 3 years ago. It went basically right through the hill country, through Gillespie County, Blanco County, and it kind of cut right through Austin and San Antonio, San Marcos, Kyle area, Lockhart, and that was one of the first big pipelines going right through that area. And yeah, I had lots of clients, Hayes County and Caldwell County. All right, a lot of times people will ask, well, what is midstream, or what is the Matterhorn Express Pipeline? Well, Matterhorn Express Pipeline LLC is an entity. It's an LLC. and it's owned by these various other entities. So these are just, why doesn't, Exxon or Kinder Morgan own a pipeline as big company? It's liability purposes, protection purposes. They want it as a separate asset always, right? And that's what Matterhorn is. So, it's a group of various shareholders or owners of the LLC. All right. Put this in here, just talk about, I mentioned the Whistler line. That's Whitewater's other project, or pipeline project. They've got a Bengal line as well. So now let's kind of talk more about the Matterhorn project. So it's 410 miles. That's the route everybody's seen. 15 counties. Here are the Railroad Commission kind of timeline filings. So March, and I lack of filling out the application complete. But what gets me is, they were already, and I was getting contacted by landowners before they even had their permit approved. They were wanting to get access to go ahead and survey. Have I had pipeline companies actually file? Just something to point out. You got the pipeline operator is, WWM Operating LLC, so they operate it by one entity name and it's owned by another entity name. The big trunk line of this Matterhorn is going to be 42 inches. So the big trunk lines or big main lines, you'll see them from 36 inch, like I said, on the Kinder Morgan line, 42. The Permian Highway pipeline was 42 inches. These other, the 30 and the 36, you may say, well, where's that? Those are on some laterals. This has been now finally, it's been getting some press, especially in Austin. KXAN is pretty good about covering this. They knew a landowner of mine, so I had a landowner say, hey, I'm going to interview with a reporter, is that okay? Normally, you say, no, I don't want you to make statements to anybody, but in this case, I said, sure, why not? Because the more pressure and public oversight, I think, and of course, there's oversight from the Railroad Commission, but I think the more oversight there is from everybody, from the news to the reporters, the newspapers, the better. That's all. We're at step. It's like, where are we at right now? We're at step 0. We're not even really gotten to step 1 yet. But because people a lot of times in their mind will think, oh no, we're gonna have when are we going to court to have a trial in this case? That's not going to happen for a while. So don't think about a trial date yet. So kind of going briefly over the steps. I know everybody can read, so I don't want to read it, off the sheet. But what's already happened to you guys? You got contacted by a right-of-way agent, to get temporary access to go on your property and do surveys. What kind of surveys? Normal civil engineering surveys, yes. But then at some point, archaeological surveys, is there some kind of historical importance to your property, is it an Indian burial ground? Is it they're going to do those kind of surveys too, possibly. They're going to evaluate, their endangered species, things like that. So, when we talk about the historic or, archaeological, normally what they do is if you've got a water body on your property, a creek or something like that, then they're gonna do some digs just off of the water body, right? Why? Because there may have been Indian encampment there or something. I don't know, but those are the kind of things that they're gonna do. I always say this: look, if you found any Indian heads on your property or arrowheads, things like that, tell me. Let's tell them. Be aware that if you think there's some protected habitat or interesting habitat, I try to use a lot of anecdotal situations so that you guys can think, well, does that apply to my property? jog around my client's property, a worse route for my client. Why? Because they were avoiding some protected snakes right there. That was the oddest thing, and the client said, "Oh yeah, we've had Discovery Channel come, and there's snakes all over the place, or whatever else." So they were actually kind of going around that, but they're also boring some of that. So it was odd. But if you've got some kind of weird special feature like that, bring it up, please. I mean, a spring on your property, I mean, anything like that, bring that up, because that's important. Once they've done their surveying and they have a good feel for this is where we want the pipeline to go, then you'll get an initial offer. And then the timing of it this is where it varies a lot. Sometimes people will get initial offers and they won't hear from the pipeline company for a long, long time. All right, so what are we hearing on this pipeline? Someone told me this, and I had another client. So I have a client that's being affected by the pipeline and is a subcontractor for pipeline construction. So they'd like to start construction on some segments by the end of the year. So 2022, end of the year is when some of the construction could start. Me talking to the lawyers, me asking that question, and not putting too much stock in what they say, but they say the first part of 2023. All right, so that's pretty quick. So by December, January, February is when some construction could start. So, and is that legally possible as far as time frame of them getting initial offer, final offer with appraisal, and then filing suit? Yeah, that's a real, that could absolutely happen. Yeah. So you get the final offer letter. That final offer, oftentimes, is it going to be the same as the initial offer? Yeah, a lot of times it's exactly the same as the initial offer. Sometimes it's lower, right? Because they, different pipeline companies, different condemners have different strategies or policy. They may, and I'm just going to use numbers, they may say, we're offering you initial offer $20,000. And then they send a final offer letter and it says $5,000. And you say, oh no, it went down. Let's take the 20, call it a day, because now we're going backwards. I mean, so that's the initial reaction by a lot of people. So let me kind of unpack that. They make an initial offer of $20,000 because we want to settle with you. That final offer is supported by an appraisal, and their appraiser is, he's hired by the condemnor, and I believe that he's going to be more favorable to the condemnor. Okay. Now, this is where, in the packets that you're going to get, you're going to get a landowner's bill of rights. That's I should have one on there up here, but it's documented. It's promulgated by the legislator. I mean, it's a statutory requirement. They have to give you landowner bill of rights. And it says this is, as a condemnor, they have to give you this information. And as a condemnor, they have to get a certified appraiser to come up with a value of what they think they should pay you, right? And so what that is trying to tell the landowner is, what the condemnor is trying to convey is, hey, we got this third-party appraiser. He's got to be right, and what he says has got to be correct. So you should accept that number. I'll be the first one to say, it's like, when I'm asking appraisers how they come up with their valuation, it's their opinion. Yeah, it's your opinion, and and we all have opinions. You got your opinion on valuation. So, do I think that their appraisers are low? Of course I do. So don't get nervous or don't get upset with a lower final offer that's supported by an appraiser, because we already know that that's what's going to happen. Does the final offer sometimes, is it exactly the same as the initial offer? Yeah. And it's almost always, it'll also say, we're offering you 20. Oh, by the way, there's an appraisal, and it only says we should only really have to pay 5,000. So, we're being generous. So, don't get worked up, don't get shook up about any of that stuff. Just know that that's all part of the steps in the process. What's the next step? These are all things they have to do to then get to filing a petition for condemnation, right? So then they file their petition for condemnation, and that's kind of when, to me, that's when things really start being important and happening, right? So they file a petition for condemnation, then the judge will appoint special commissioners. And this is where, a condemnation proceeding is different from a normal litigation. Normal litigation, file a lawsuit, conduct discovery, set a trial, and then, ultimately there's a trial. The condemnation proceeding, they file a lawsuit, and it goes through this administrative process of the court appoints special commissioners. Let's see where we're at. Yeah. So the judge appoints special commissioners. It's not the county commissioners. 3 landowners from the county that are, familiar with land, hopefully, and that the judge, there's some connection with the judge. The judge knows them. They're either realtors, oftentimes, and those are your 3 special commissioners. All right, let me get kind of a little bit more into technical stuff. The judge will appoint 3 special commissioners and 2 alternates, and either side can strike 1 special commissioner. It's called for no reason whatsoever. And it's not for cause, just you can strike 1. And the new laws have kind of required the judge to appoint special commissioners right away, and then it allows 10 days for us to strike a special commissioner. So you don't have a lot of time to strike. The law before didn't have any, it just said within a reasonable amount of time. Well, what's a reasonable amount of time? We never knew, so now it says 10 days. So you as a landowner, it's really important, and this is, I'm just going to say it this way, what I do right away when those special commissioners are appointed, I send my clients, these are 3 people that are appointed, this is what we know about them, do you know something about it? Because, smaller counties, you maybe went to high school with one of them, or maybe you guys got in a fight over a girl, and he don't like you and you don't like him, or whatever. I've had those situations where it was like, yeah, I don't know any of them except this one guy, and he is whatever, my best friend, he's great, or he's terrible, or we don't want him, or whatever else. So we need to know, your perspective of the special commissioners. We can strike them. Now, I've had them where sometimes, this was on a power line easement. One of the special commissioners worked for the power line company. Well, that's not going to work, and we struck that person for cause, and we still were able to strike another one. So just kind of know if your lawyer talks about striking someone, that's what that means. It's like if you're on a jury panel, or you're on let me go. So you get your special commissioners, people strike or don't strike, and then, the law firm for the pipeline company is going to try to set up a special commissioners hearing. Let's talk about that, because that's not enough is discussed about a special commissioners hearing. So, that's where pipeline company will put on their evidence for damages. Hey, how much should we pay the landowner? And then the landowner gets a chance to talk about, what they think they should be compensated. Extremely important, the special commissioners don't rewrite the easement agreement. We meant the law, this is Northfleet, we talked about that, the law firm, Zabel Freeman, firm out of Houston, they're kind of on the eastern part of the route. Ross Molina Olivares, San Antonio firm, they're kind of on a more middle section. Also mixed in there is Jackson Walker, Austin. So, a couple years ago, Farm Bureau had a big campaign to push for landowner or eminent domain reform. And this is a little video I'd show. It just kind of bashes right-of-way agents about how they're real tricky and everything else. I won't go in. It's a couple seconds long, but we don't need to watch it. Right-of-way agents. Let me talk about right-of-way agents real quick, and then I'm going to jump into special commissioners here. So remember, the right-of-way agents, don't represent you, right? They represent the pipeline company. They represent Matterhorn. They don't represent you. I get into this, and I've had right-of-way agents comment on my blog and send me dirty messages saying, why whatever, why do you hate right-of-way agents? Because I've seen really bad right-of-way agents, and I've seen ones that are, good. I know some of them, because I've dealt with them enough, and they are helpful, and they get me information, and I appreciate it, and it's good. And other ones have misrepresented what the easement document says to landowners, and landowners have signed it. This is kind of true story. Why do I do this type of work? I had a client call me a long time ago and say, hey, I need you to take a look at this easement agreement. We need to make some changes. Okay, perfect, no problem. Send it over to me. It was a pipeline. He had already signed it, and he wanted to change it. And I said, you've already signed it. Yeah, but the guy told me that we could always change it, so that's why I'm calling you. He didn't hire anybody. He didn't hire me. And I said, so that's why I like to kind of give everybody a heads up and say, be careful with right-of-way agents, because you never know. Now, luckily, the legislature recently, last 2 years ago, created some more kind of oversight on right-of-way agents. Like, they've got to be more ethical, and they've got to do this, and if they don't, then they get in trouble. Well, anyway, I kind of point this out too. This was in a pipeline journal article talking about, if an appraisal is required, this is kind of right-of-way agents talking about, hey, it's not like it used to be, even though I still see this. If an appraisal was required, then a reliable economic approach was used across the fence, which determined the property value based upon whatever the next door property was. But then it's like basically, but if that didn't work, and if things got sticky or time consuming in negotiating with the landowner in question, the agent could always play the condemnation card and threaten to invoke eminent domain seizure. It kind of says, well, those days are kind of over. You will still hear that, in any interactions you have with a right-of-way agent. It was like, well, we really want to work this out, but we're not. We're going to have to file on you, or we're going to, we'll get the lawyers involved or whatever else. And I'm always the first one to say, great, please file the lawsuit so that we can deal with the law firm and not you guys. So anyway, don't be worried about them filing the condemnation petition. That's, I've got some do's and don'ts. Don't provide, these right-of-way agents are going to send this form that you probably already received saying, do you give me permission, and then give me information about your property. You don't need to give them any information about your property. There's a time and a place for us to have to provide information if they ask us in a proper way or right way. Right-of-way agents will always, one of the first things they'll say is, I've known landowners to state an amount that they'd like before they even surveyed the property. This was Kinder Morgan on the PHP. I knew guys that said, oh yeah, I told them I wanted X when the right-of-way agent was just coming to get, access to survey. That's like doing everything completely backwards. We never talk about money until we know exactly what is going to happen on your property, and then we know, once we nail down the easement, the route, the easement terms, and on the easement terms we try to limit it as much as we can, and then we finally start talking about money. And that's exactly the opposite way they like to do it. Do reject the first offer and all that. Easement terms, you'll hear this over and over from me, but we always want to work on the easement terms. If not, if we didn't, what kind of easement would they get? They try to get an easement that allows multiple pipelines, unlimited ingress and egress all over the rest of your property to get to the route. All this kind of stuff. So we like to limit. We have to limit the line or limit the easement document from the diameter of the pipe, all that stuff. Other key terms, restoration, really work on that. Above ground appurtenances. Why? Because, this is what I'm talking about when we're talking about above ground appurtenances. So these are other things, and I have these photos in here because, above ground appurtenances can include cathodic protection test leads. That's an example of single H bracing on a gate. These are all things that we're going to have in the easement agreement. Negotiating. So, okay. Yeah. So now let's get back. This is kind of where I wanted to get to answer your question. The special commissioners don't fix the easement terms, right? So when we go to the special commissioners hearing, what's going to be talked about is, Matterhorn's filed suit. They filed a condemnation suit. We are at the special commissioners hearing there's 3 special commissioners, and they're evaluating how much you should be paid. So there's one blank, and they're going to fill in the number. They're not going to fix the easement terms. They're not going to do anything like that. I mean, it is what it is, what they're seeking in their petition. So what does a special commissioners hearing look like? We go there. Condemnor is going to start first. Well, really, Condemnor lawyer is going to start first and have an opening statement. Maybe it takes 2 minutes long. I'll have an opening statement. It takes about 2 minutes. And then the pipeline company lawyer will put on their evidence or their case. And that may take an hour, hour and a half. They'll normally have a company representative there that will talk about how wonderful this project is and how it's going to help everybody in the world. But also, the more details of the construction. Why they need what they need in the petition. And then I get to cross-examine their company rep, and then they put on their expert, the appraiser from the appraisal company that you got a copy of, and he's going to go through his appraisal and just kind of walk them through and explain how he came up with those numbers, right? And then I get to cross-examine him, and then normally that's about it for their side. And they'll say, we're done. We think you should only pay him $5,000, and then we get to put on our evidence. So what do? It varies. Of course, we put on the landowner and say, we go through the land, how long you had it, special features of the land, and then you as a landowner, there's a rule in Texas called property owner rule. You can give an opinion as to the value of your property. What do you think the value of your property is based upon what you know about the market and the property selling in the area and all that kind of stuff? I think my land's worth $10,000 an acre or $20,000 an acre or whatever. So you can give an opinion as to value. Yes, I put on the landowner. Sometimes I put on, sometimes we do get an expert at that stage in the case. And we'll have our own expert there. And we'll let our expert give his opinion as to value. He will have prepared a report and all that kind of stuff. Do I have other witnesses there? Sometimes, yeah, if there's a lot of trees affected, we'll have an arborist there, or we'll have the arborist report. It just varies on what's going on with the property. If you've got a tenant, a farmer's going to be affected, we'll have a farmer there and we'll talk about that. They get to cross-examine, you the landowner. They get to cross-examine our expert, the farmer, whoever. And then we give a real brief closing statement, 5 minutes each side, and then that's it. And then the special commissioners deliberate. They take, 10 minutes, 15 minutes, and it varies. And then they'll, normally if it's a in-person special commissioners hearing, we'll all hang around and then they'll announce the award and sign an award paper, and that gets filed with the court. Why is all that important? Is because at that moment when they come up with an award, file it with the court, and the condemnor, the pipeline company in this case, deposits that amount that's been awarded into the registry of the court, then they get a writ of possession, which means they get to start their project. Whatever they're asking for in their petition, that's what they get at that moment. So they get an easement on your property. Even though you said, but I didn't agree to it, I didn't sign anything. Correct, you didn't sign anything, and they have taken an easement on your property. Now, is that over? Is it done? This is where we kind of go back to the steps. We're now at step, 11, 10 and 11. What if I don't like the award? What if it's wrong? What if it's too low? You know, in my opinion, you have an opportunity to object to the award. You object. You look through your lawyer, we object to the award. And then the case, and this is where it boggles most people's mind because it is weird, it's different. The award, think about the award, you know, just think about it this way. It gets set aside, essentially. And the case goes into normal litigation, civil litigation. Now, what does that mean? You know, that means, like I said, the back and forth discovery, taking depositions possibly, but ultimately there's a trial date. And if you don't reach a settlement or a resolution in the case, there's going to be a trial and a jury is going to decide the amount to write in that blank, right? And that's all the jury does too. Right? The jury's not going to decide easement terms. The jury's not going to say, we think 75 feet is way too wide, it should only be 50. All you need is 50 foot. They're not going to decide that. Or, you know, there really shouldn't be, you know, a real broad, you know, any above ground appurtenances for the operation of the pipeline. That's not, you know, that's not part of it. So that's kind of, like I said, big picture of special commissioners here in more detail. So special commissioners hearing takes about a half day, you know, sometimes a day. You know, what are the damages, you know, or just kind of long story short is let's say property's going for $20,000 an acre, okay, and their pipeline is going to take simple math, you know, 1 acre of your property. So this is where we get on, it gets all muddled. We're talking rods, we're talking feet, and then now all of a sudden, Philip, you've said 1 acre because that's how much the permanent easement's being taken. But I'm talking about what an appraiser is going to calculate out. He's going to say, how much is the part being taken? It's 1 acre of easement, $20,000. But they're taking an easement, which is not 100% of your property. You know, if it was TxDOT taking 1 acre of your property for a highway and they're literally taking it from you, fee simple, not an easement, that's 100% of your property. But Matterhorn is going to be taking an easement. It could be a very burdensome easement or a little bit less burdensome, right? But you know, let's just say it's 90% taking of your property. So it's 90% times $20,000. That's the value of the part taken. You know, and they're not going to really dispute that. I mean, they may dispute. No, we think land in the area is for $10,000 an acre, not 20, because they're going to use comparable sales, you know, this comparable sale and that comparable sale, that's 10,000, 8,000, 5,000, 10,000. You know, we want to find sales out there of more realistic sales. Oh, there's a sale for 20,000, 18,000, 22,000. You know, I mean, that's how we come up with values. But then sometimes they will say, oh, but the easement's not that big a deal. It only affects the property to 70%. And I think that's incorrect. I think it's like a 95% probably, right? Because like I've gone over and over with them. Oh, yeah, we still own the dirt. We can walk on it. A cow can walk on it. But that's about it. We can't build anything on it. We can't, you know, can't do anything on it. We can't even change the grade sometimes. I mean, so can we, if we need to improve drainage, can we blade it a little bit? Well, maybe not. I mean, you know, so it's very burdensome. So when you're talking about damages, that's the way you come up with damages. Now, if you're saying, you know, the value that you have to look at is kind of in the foreseeable, well, what are the comps now? What are the comparable sales now? Not in 100 years from now, the land's going to be worth $100,000 an acre. You know, and you can't look that far in the future. But and this may affect some of you. When you look at what the highest and best use of the land is, what does that mean? Well, your land may currently be right down the road and it's a hayfield, right? But it's on I-10, and so its highest and best use may be, well, it's retail commercial or something, you know, and that's not, you know, that's $100,000 an acre or something, you know. So that just varies, but but the big component that's really important on these pipelines is, and this goes to a lot of your properties, is what's the damage to the rest of my property? I know it's taking 1 acre, but I own 100 acres. It's reducing the value of the other 99 acres. You know, and I almost guarantee, because I've seen enough of the pipeline appraisals to say, oh, no, there's no damage to the rest of your property. You know, I believe there is. Many experts believe that there are. I think most of the landowners say, yes, there is, right? So that becomes oftentimes the biggest point of contention, right? Is the damage to the remainder of the property. Y'all follow what I'm talking about there? I mean, that's a big part. So, you know, other damage components, you know, they're going to have a temporary road or road access. That's a whole other easement. Loss of, you know, like I said, production, cost to cure damages, things like that. So, I mean, if you've got a, you know, a levee or berm on your property and then they're cutting right through it, you know, that's some damage. You're going to have to rebuild it or not. So, this question comes up. Well, okay, so do I get paid my attorney's fees in a case? You know, case goes all the way to trial or close to trial, let's say. I mean, well, heck, you know, their lawyers, you know, they got a whole team of lawyers, and I've got a lawyer. Don't we get our attorney's fees paid for? No, the answer is no. You don't get attorney's fees, and that's why. And that's kind of one thing. I mean, that's why most lawyers that handle condemnation cases, and me included, I do it on a contingency fee basis, because, you know, attorney's fees aren't awarded, right? So, you know, and I talk about this contingency fee because I want everybody to understand it very clearly, and that's if you're working with me or if you're going to go find some other lawyer and talk. You know, I want you to understand what the contingency fee arrangement is, and this is, you know, works for all the lawyers, but for the way I work is, you know, we establish a base. Your initial offer, you're going to get that initial offer. Whatever you get offered, that's yours, 100%. My job is to whatever we can get above that. You know, that's what's used to calculate the fee. So whatever the initial offer is, that's yours. Anything above that, then there's it depends on the percentage. And I say, I mean, I've seen some lawyers work for 40%, 45%, and others at, you know, 25%. And you may say, well, of course, we're going to go with the 25% because that's cheaper. You know, sometimes you get what you pay for, but also be careful with some of the next things I'm going to talk about. And my rate, a third. That's what most landowner lawyers charge. Be careful with the case expense part. What does that mean? That's always kind of like to say, read the fine print. So I see some lawyers charge for case expenses. Well, what does that mean? So for some lawyers, it means that like everything, mileage, postage, and, you know, you name it, they're going to charge you in addition to the contingency fee for their case expenses. And I just always say, I don't do that. What are our case expenses? If we need to hire an expert, that's a case expense. And that's something that the landowner typically pays for. So that's an expense in addition to contingency fee, mediation costs, deposition costs, things like that. Yeah, those are case expenses. But I've seen other lawyers where it's, like I said, for anything and everything. So be careful with the case expense part. You know, people always kind of say, this is all good, but what do I need to do right now? You know, someone said, yeah, you had the story. No, you had the story of taking pictures. You know, it's always good to document before, after. This is what the land looked like before the pipeline.
This happened during the case.
Yeah. So I always like, please, take pictures now, right now. I mean, because there's different seasons too. So get good pictures of what your property looks like in the summer. And what I typically do is, I've got a drone, and I'll take a drone out and drone everything, and that's helpful too, because once the pipeline goes in, then we like to do the after, and there's lots of really nice trees, and now there's this swath that is cut with the pipeline. So anyway, if you've got improvements like pins or fences or gates or a well, water well that if those things are going to be affected, it's good for us to be able to show, look, I just put the well in 2 years ago, and this is how much I paid for it, and I got a quote now, this is what it's going to cost to put another one because we're not going to be able to use this one or whatever. So that's all helpful. But also, anything and everything you get, I mean, this is kind of standard stuff that everybody does. Keep everything you get from the right-of-way agents, pipeline company. You've got a lawyer, obviously send that stuff to your lawyer. Keep them informed. Anything that the pipeline company, right-of-way agents say, jot that stuff down. I think all that stuff's helpful. This is just if somebody were to ask, well, hey, I thought there was this eminent domain reform stuff out there. What changed and how did it help us? Almost every year, or every 2 years, Texas Farm Bureau or other kind of land owner organizations push for eminent domain reform, and sometimes parts of it passes, sometimes it doesn't. I just remember, I've said this before and I kind of say it again, just remember where we are in the process. It's May 2022 and we're at step 0 and 1. So how soon can you expect getting an initial offer? How soon can you expect getting a petition? I think you could potentially get an initial offer within the next 2 months, and then, a petition, I could see petitions going out, October, September, October. So that's kind of the timeline right now. That's what I see. Keep up with what's going on, So the whitewatermidstream.com, that's Whitewater's website. Are they going to put a lot of timely information up? Not really, but it's worth checking. The other one, the condemnationrights.com, that's my website. So I put up a lot of information. I try to put it up timely. I shoot videos to try to just help people. I'll put this on my website as well. So if there's something that you said, well, he said something at the talk, but I don't remember what he said, this should be up there, I don't know, in a couple days.